Thank you, Rabbanit Michelle, and thank you also to Rabbanit Shimoni for her words. I'm going to think about them for a long time. I want to dedicate my talk today to the success and safety of our soldiers, to the safe return of the captives, in memory of those who have fallen, and for a refuah shlema to all those who are injured. I also want to dedicate my talk to Dr. Judith Howman, who was my first Talmud teacher in 1977. After learning Talmud from her during my sophomore year in college, I am sure I thought that studying Talmud was the exclusive province of women. One of the classes first-year law students are required to take is a class in torts. Torts are acts or failures to act that cause harm to persons or property. Torts was one of my favorite classes in law school, and you're thinking, how could that be? It was more understandable than some of the more arcane classes that we were required to take, like property or contracts. In torts, one party takes an action or omits to take an action, and the other party or property is injured. The question often revolves around who in the dispute was negligent. Negligence means whether a party took proper care in doing something. Failure by a party to take proper care means that party is negligent. So in our study of Bava Kamma, a muad ox, one who had hurt another ox or human at least 3 times, was considered forewarned, which meant that the owner of the ox had an obligation to mitigate or reduce the damages the ox could cause. Many torts cases, including those in our Masechet, are decided based on whether or not one party was negligent and whether there was a duty for the injured party or the party responsible for the injury to have taken an action or omitted to take an action to mitigate the risk of the negligence. Think about the stop, look, and listen rule. So for those of you who are too young to remember railroad crossings without safety arms, they often, and who grew up in America, I might add, they often had a signpost with an X on the top, and on the crossbars was written, stop, look, and listen. I tested this out with my millennial son who had no idea where it came from. The rule was developed by a train engineer who thought those 3 words associated with a train would allow immigrants to understand its intent and pay attention to their warning. However, many of you may not know it was actually used to adjudicate cases. Imagine the rail crossing with a safety arm. One of the first cases, imagine the rail crossing without a safety arm. One of the first cases to use the stop, look, and listen rule was decided in 1858, when a cow herder in Pennsylvania sued a railroad for the loss of 300 cattle when the train ran over the cattle as the cow herder sought to drive them across a railroad track. The cattle were on the track as the train approached, and the cattle met the moving train. Who was negligent? The cow herder or the train engineer? The court held that the cow herder had a duty to stop and look out for trains and could not rush heedlessly nor remain unnecessarily on a spot over which the law allows trains to run. In fact, the court called trains, which were fairly new at the time, engines of fearful power to be propelled by one of the most resistless agents of nature. So to distill down this decision, the rule was that since an individual knew the dangerousness of a train, similar to the muad ox, they were obligated to do what a prudent individual would have done in the situation to mitigate the damage. He should have stopped, looked, and listened before crossing. The issue of foreseeability always comes up in these cases, and the question that is asked is whether a person could or should have reasonably foreseen the harms that resulted. Should the cow herder have stopped before he began to herd his cows over the tracks and looked and listened for an approaching train? If resulting harms were not foreseeable or a plaintiff failed to mitigate a foreseeable risk, a defendant might successfully prove that they weren't liable. In both the stop, look, and listen case and the case of the muad ox, the courts and the Talmud have held that it's reasonable that the ox owner or the cattle herder should have foreseen the damage the muad ox could have done, or the risk that the cattle would have been killed. The owner of the muad ox by more carefully guarding the ox, and the cow herder by not advancing the cattle across the tracks if after stopping, looking, and listening, he thought a train was coming. So as a merger and acquisitions lawyer, much of what I do is help my clients understand the risks they take as buyers or sellers of businesses. As sellers, clients want to walk away from a transaction and make sure they have no liability after the business is sold. Conversely, as buyers, clients want to make sure that any liabilities that resulted from the time before they bought the business are not their problem as buyers, and they can get reimbursed from them by the sellers. So it is always a dispute between in a negotiation. But the concept of reasonable foreseeability often is used to allocate the risks between buyer and seller. For example, I had a transaction recently where the buyer did think that they could hold the seller liable for anything under the sun that happened after the transactions closed if it happened during the time that my client, the seller, owned the business. They proposed language that our clients would hold them harmless for any claim, assertion, loss, liability, deficiency, on and on and on that occurred after closing, but related to the period before closing. And then we were able to get them to assert forwards into the language in the document that limited our clients' liability considerably. The buyers agreed our clients were only liable for damage resulting from those matters that were reasonably foreseeable. Of course, there was a possibility we would dispute later what reasonable foreseeability meant, but that's been adjudicated many times, and we weren't too concerned about having to define it specifically because it's definable as in legal cases. So the concept of reasonable foreseeability, whether it's an ox that is known to hurt others, a train that may cross the tracks when a herd of cattle is coming through, or a seller who is trying to limit its rights to future liability, focuses typically on an individual and on a situation between only two parties, one ox, one owner, one injured person, and so on. However, as we were studying the Masechet, I began to think about how or whether the concept of reasonable foreseeability can be extended to the community. Can a community consider themselves warned for prior actions and be responsible to act prudently to mitigate such action in the future? So the logical extension of this concept to the world we live in now is to look at October 7th, 2023 as the forewarning, requiring us to act prudently to mitigate the damage. On a personal level, my husband and I heeded this warning by spending time in Israel, volunteering this past January, housing evacuees in our home in Jerusalem, and listening to our friends and family as they described their lives since October 7th. We plan to return during Pesach for more volunteer work and then to make Aliyah at the beginning of July. Learning the Masechet of Bava Kamma for the first time during this communal warning and call to action will stay with me for the rest of my life. And the lessons I have learned by integrating my knowledge as a lawyer and my commitment and compassion as a Jew, I am certain have changed forever how I will read Bava Kamma. Thank you.